Good morning, everyone. The House Judiciary Committee will come to order. Will the Secretary please call the roll?
Chairman Briggs.
Here.
Representatives Abney.
Leave.
Carroll.
Leave.
Donahue.
Leave.
Hanbidge.
Leave.
Hohenstein.
Leave.
Howard. Kenyatta.
Leave.
Kincaid. Mays.
Leave.
Pielli.
Leave.
Rabb.
Leave.
Sanchez. Schusterman. Chairman Kaufman. Okay. Representatives Bonner. Borowitz. Ecker. Ham. Kale. Kerwin. Clunk. Kuzma. Ledbetter. Rigby. Shalaba. Mr. Chairman, a quorum is present.
Thank you, Madam Speaker. I want to take a moment to thank all the members who are present this morning. I know it's a busy day and a busy week for everyone, and we appreciate you being here. For the information of the members, this meeting is being live streamed and recorded. Today we are coming together for this informational meeting on DNA collection in the Pennsylvania criminal justice system. I'm looking forward to hearing testimony on this very fascinating topic, and I want to thank all of our testifiers for joining us today. For the information of the public and the members, we have received written testimony that will be included in the record of this informational meeting. It's in packets on the side tables. Next, we will begin our hearing from testimonies. Testifiers, each of you will have 10 minutes to deliver testimony. Once all the testifiers have finished, we'll open the floor for questions from members of the committee as time permits. We are on the floor at 11. Our first testifier, and I think we're going to go from your left to right, is John Roman, Director on Public Safety and Justice and a Senior Fellow in the Economics, Justice, and Society Department with the National Opinion Research Center at the University of Chicago. That's a long title. Thank you for agreeing to testify today. You are in order to begin your testimony. Thank you, Dr. Roman.
Well, good morning, Chairman Briggs, members of the committee. I'm honored to discuss the important issue of expanding eligibility for inclusion in Pennsylvania's DNA index system to solve more crimes, reduce the risk of wrongful conviction, and improve public safety. So over the last 2 decades, the scope and scale of the combined DNA index system, which is broadly known as CODIS, has expanded substantially. Since the system was initiated in 1998, the number of participating states has gone from 9 to 50. And the number of profiles included in CODIS has increased almost tenfold from 2.9 million in 2005 to 25 million this summer. And the types of offenders and arrestees eligible for inclusion have also expanded. Despite substantial growth in CODIS, the database's effectiveness as an investigative tool and as a deterrent has remained limited. Specifically, outside of the most serious crimes, CODIS is used infrequently to aid criminal investigations. In particular, DNA is rarely used as an investigative tool in high-volume crimes, such as residential burglary. And even in serious violent crimes, DNA is often used as leverage in plea negotiations after an arrest, rather than as a means to identify unknown criminal offenders. There are several reasons why CODIS is not used more often to solve crime, but a key reason is that by limiting CODIS eligibility to those convicted of the most serious crimes, people in CODIS are likely to serve very long sentences, and thus practically, CODIS remains quite small as an investigative aid. Expanding the database would improve the effectiveness of DNA as an investigative tool. So growth in the use of DNA to aid criminal investigations has been slow. In the 2000s, it was 10 to 15,000 cases a year were aided by DNA. By the 2010s, it was more like 35,000 cases a year. And again, this is across 50 states. And even in the 2020s now, we're talking about like 50,000 investigations aided. Given that there are almost 2 million violent crimes and serious property crimes annually, this suggests that perhaps only 2.5% of criminal investigations were aided by the collection and processing of biological evidence from a crime scene. In fact, the number of cases aided is actually likely far smaller, as this includes case-to-case matches, where evidence is linked to evidence rather than evidence being linked to a person. And many crime samples, as I said, that are tested in CODIS are tested to confirm rather than identify a suspect. Okay, so CODIS potentially reduces crime in 2 ways. So CODIS serves as a direct input into criminal investigations, providing investigators with a tool to identify unknown suspects that is substantially more effective and efficient than alternatives. In my own research years ago when I worked at the Urban Institute in DC and in partnership with the U.S. Department of Justice, we found that collecting and testing biological evidence from high-volume cases, specifically residential burglaries, led to the identification of a perpetrator more than 2.5 times as often as traditional investigations and led to an arrest twice as often. Developing DNA evidence was 3 times more effective at identifying a suspect than was fingerprint collection and testing. And the cost of all of this added stuff, right? Collecting DNA evidence, testing it, and then the added burden of actually having to go out and find a suspect that you otherwise wouldn't have known about, only costs about $3,500 per arrest. So it is, in the larger scheme of things, a very inexpensive way to dramatically improve the efficiency of police investigations. The other part of this that's really critical that doesn't get highlighted enough is that in this study, what we found when we looked at the criminal histories of people who had been arrested for a residential burglary via an identification through CODIS from biological evidence left by the suspect at the crime scene and then matched in CODIS, we found a pattern of serious chronic offending in this population. So the average person who was identified in a DNA-aided investigation had 6 prior felony arrests and 3 prior felony convictions. The average person was a 3-strikes offender, and these were not serial burglars. These were people who committed a whole array of serious person crimes. Second, collecting more DNA from more people would deter more potential offenders. So using DNA reduces crime and improves public safety as the active use of CODIS serves as a deterrent to criminal offending across the population of potential offenders. Recent research has shown that the number of offender profiles in CODIS is an important predictor of the probability that DNA will aid a criminal investigation. So, simply, as the size of the database increases, the likelihood of an investigation being aided increases equally. A larger CODIS DNA database increases the probability that a suspect will be identified and arrested, and since potential offenders are aware of their risk of being caught, it will deter some potential offending. This is known as general deterrence, where increasing the signal through higher clearance rates that people who commit crimes will be caught reduces the number of people willing to commit crimes at all. So let me just say a quick word about fairness. Expanded use of DNA evidence collection and testing reduces the likelihood that any person is wrongfully arrested and convicted of a crime they did not commit. CODIS-aided investigations have many advantages over traditional investigations, including advantages over fingerprint comparisons. Specifically, the probability of a match between DNA from a crime scene and a suspect's DNA can be precisely estimated. The error can be quantified. By contrast, there is no objective estimate of the probability that an eyewitness testimony or a fingerprint match is correct or an error. As a result, DNA both reduces the likelihood of wrongful conviction and increases the likelihood of apprehending the true offender. Critically, adding arrestees to CODIS moves discovery of wrongful detention much earlier in the process, from the conviction stage to the arrest stage, which makes it much easier to correct. Doing all of this will require additional resources once the database is expanded in order to facilitate more DNA-aided criminal investigations to increase detection and deterrence. To optimize the expansion of the CODIS database, DNA must be used more often and in more cases. Expanding the collection of biological evidence from crime scenes and more crime scenes of more type, including high-volume crimes, can identify more unknown suspects and improve public safety. The available evidence supports expanding eligibility criteria for inclusion in CODIS to improve public safety, reduce disparities, and facilitate more just outcomes. Thank you very much.
Thank you very much, Dr. Roman, for your participation and sharing your expertise on this issue. Next, we will hear from Ashley Spence, founder of the DNA Justice Project and author of Silent Witness, How DNA Uncovered the Truth and Empowered My Healing. Ms. Spence, thank you for your time today, and you are in order to begin your testimony. And if just pull it a little bit closer.
Oh.
Yep. Thank you.
Good morning, Mr. Chair, members of the committee. My name is Ashley Spence. I'm the founder of the DNA Justice Project, and I'm honored to sit before you here today, not just as a mother, but as a survivor. I was 19 years old, about to begin my sophomore year at Arizona State University. While I was asleep in my bed, an intruder came into my apartment, smothered my face with a pillow, tore off my clothes, and began to rape, beat, and nearly killed me. I was forced to endure this torture for hours, and he got away. I never saw his face. Before he left, he said, "Do not tell anybody, because just like I was watching you before, I am watching you now, and I will come kill you." In spite of that, I worked day and night with detectives, but there were no leads. The fear was paralyzing, so I dropped out of school. I moved to Newport Beach, California, before relocating back to my home state of Austin, Texas. It was there 7 years later, I got the shocking news. There was a DNA match in my case after 7 years. And ironically, I moved to Newport Beach to escape this monster, but in reality, I moved to the very city that he lived. When he was apprehended for an unrelated offense, they found him just 1 block from where I lived in Newport Beach all those years. He was trying to break into a home where 3 young women lived. An officer saw him. They got into an altercation, and he ended up eventually resisting the officer's arrest, which is a felony in California. California is one of 19 states that collects DNA for every single felony arrest, and this is a process that changed my life forever. They uploaded his DNA into our national DNA database, CODIS, and it hit a match back to mine and multiple others across state lines. He was a serial predator with a wife and a son, and a shed behind his home full of women's underwear and ID cards from all over the world. I was not the first, and 7 years went by. I was not the last. Now, we waited on trial for a very, very important Supreme Court ruling. So in 2013, Maryland versus King, they found that taking your DNA for a qualifying arrest is a reasonable part of the booking procedure. They actually compare it to fingerprinting, and therefore reasonable under the Fourth Amendment. We went to trial, and he is now in prison for 137.5 years. I am so fortunate to be here and to have justice, but all victims deserve justice. And sadly, victims will continue to have justice withheld due to outdated DNA collection laws and technology. So here's the truth. As the law stands in Pennsylvania today, had my perpetrator been arrested, you would not have swabbed his cheek, and he would still be free today to rape and harm and terrorize his next victims. Currently, all 50 states collect DNA upon felony conviction. 31 states collect for certain violent felony and burglary, so it's a similar model that we hope to adopt here in Pennsylvania. And my home state of Texas became the 19th to collect for all felony arrests. So in 2019 in Texas, we passed this law to collect for certain violent felony arrests and burglary. In 1 year, they closed over 240 cold cases. The second year, over 630 cold cases. Now, and everyone noticed, okay, no one's being harmed by the database. We're solving crimes, we're giving justice, we're saving lives, we're saving money. In 2023, we passed through to collect for every single felony arrest. Texas DPS just announced that they closed 1,005 cases through this alone. So this system is proven, and it is a really good system. CODIS is safe and protected and private. So it is not your entire DNA that goes into the database, it's a DNA profile, and that is something very, very different. So genetic scientists actually picked out of our 3 billion markers that make us human, 20 to 24, and there's no coding information except for male or female. It wouldn't say, I'm Lebanese, if I'm predisposed to any genetic diseases. What street I live on, it doesn't even have a name. It's simply a automatically generated from the lab system ID number. Now, the names are kept in a private offline system, and only a small number of people in the labs have access to that. If there is a match in these numbers, the name can only be released to the team that is investigating the case. They still have to use that as a lead. They have to get a search warrant. From that, when they arrest them, they can take a second swab of DNA. Now, if that matches, that is what is admissible in court. So the DNA database is not accessible by third parties. You will not be precluded from getting a job by having it in there. It's not, you can't see it, but what is public is your arrest record, but not your DNA. And furthermore, which I think is the most important, it is a federal law and requirement. If you're found not guilty, you have to be able to have your DNA completely expunged and destroyed from the system. Now, the Office of the Inspector General, they do annual audits on the lab as well as random, and there are heavy fines and jail time if this is not followed through with. So in 2000, a man, Jeffrey Griffin, was charged with 8 murders and aggravated sexual assault. If the state had required him to give his DNA sample 5 years prior when he was arrested for felony possession of controlled substance, they would have found a DNA hit to another rape. So 8 homicides and 1 rape that we know of would have been prevented. So not only do we save lives, but we do save money too. The Department of Justice with the University of Denver, they found a study that for every $1 invested in DNA, $90 is ultimately saved. And Dr. Jennifer Doliak, she is phenomenal. She found that for every $35 cheek swab that is entered into CODIS, the taxpayer sees $27,000 in savings. I mean, a win-win. For 7 years, while my rapist was free, what haunted me the most, I survived, but was I would hear the muffled screams of his next victim in my head. He was out there, and I knew he wasn't stopping. But now, through forensic DNA and DNA collection policies, he will never be able to harm another person again. Now, although in Pennsylvania today he would be free, we have the power to come together to start to change that. And you all do, I want to say, the most incredible work to provide justice, to protect your communities. And this would only continue to build upon your great successes. So I really am so honored to be here, and the last thing I want to say is this policy would not just provide justice to countless victims and their families. It protects the privacy of those that are arrested. It exonerates the innocent, and as a mother, it really prevents these horrific crimes from happening to our children. I thank you all so much for your time and your attention, for all the work that you do. I am greatly honored to be here.
Ms. Spence, thank you very much for sharing your moving story. We commend your strength and advocacy as you continue to be a voice for survivors. Next, we will hear from James Tillman, an exoneree and author of The Power of Conviction, My Wrongful Conviction, 18 Years in Prison, and the Freedom Earned Through Forgiveness and Faith. Mr. Tillman, thank you for making time to share your story with us today. You are in order to begin your testimony. Thank you.
Oh, hi, everyone. God bless everybody. My name is James Tillman. In January of 1988, I was wrongfully accused of raping a young woman in Hartford, Connecticut. I was identified and wrongfully convicted on the strength of victim testimony. A woman who did not know me, only recalls her assailant face through the fog of the trauma of the crime that was committed against her. She was robbed, punched in the face, sexually assaulted. It was certainly a horrible crime that deserved punishment. But convicting just anyone is not justice. We must identify the right person. I was convicted of this crime and spent 18 and a half years in prison. It was only because of the power of DNA, DNA evidence that I was finally and fully exonerated of this crime and released from prison in 2006. After my exoneration, the evidence from the victim's rape kit was loaded into the national database and was matched to another prisoner. I was free, and the real rapist will be held accountable. If arrested DNA had been the law, and if all rape kits was tested and uploaded, the guilty man would have been identified years earlier when he was first arrested, and I would have been a free man much sooner. Every time someone is wrongfully accused, the guilty party walks free. We owe it to ourselves, to our aunts, cousins, mothers, daughters, to not allow a handful of bad actors in our community to make life a living nightmare for others. DNA is the truth. DNA is justice. DNA profile and CODIS knows no bias. DNA do not look at the color of my skin or the neighborhood I live in. It only knows the truth, and the truth is that we cannot afford not to use this science to ensure our criminal justice system is freeing the innocent and identifying the guilty. DNA made police and prosecutors reconsider their assumption about me. DNA changed my life. I only wish DNA had been required up front when I was wrongfully accused and arrested for a crime I did not commit. DNA could have absolved me of this crime and of any connection to other crimes before I spent 1 day in prison. I am here today. I strongly believe in the power of DNA, and I ask you to pass SB 912, which could use DNA more like fingerprints. Using DNA more frequently to accurately identify suspects will at the same time also ensure that we are not inaccurately accusing the innocent. My life is good now. I have graduated from college. I am married to a wonderful woman, and I have my book, The Power of Conviction. I am blessed. I am often asked, how do I keep such a positive outlook? How I'm not left bitter at years I lost in prison. There is no easy answer to this. It's a decision I come to that I have to look forward and not look backwards. I have to make the best of my rediscovered freedom, and that I have the responsibility to be a proponent for forgiveness as well as change. I sincerely hope Pennsylvania will join this nationwide movement to close the loophole in your DNA database laws, which allow criminals to hide in plain sight and also allow innocents to stand falsely accused. DNA is true. We should be using this true finder not only to make sure that the innocent people like me that's not wrongfully accused, incarcerated, but also to make sure that people who are responsible for crimes are held accountable. DNA proved my innocence and set me free. We need to use this powerful scientific tool to solve crimes, bring resolutions to victims, prevent crimes, and prevent those innocent of committing crimes from being falsely accused and incarcerated. The innocent citizens of Pennsylvania deserve this.
Thank you very much, Mr. Tillman, for sharing your personal testimony with us and advocating for justice for victims and those who have been wrongfully convicted. I appreciate you coming down from Connecticut. We have been joined by a couple members of the committee, Representative Rabb, Representative Ledbetter. Oh, sorry. I thought you snuck in and out. And also Representative Delosier, who used to be a great member of the committee and now just wishes she was. Thank you for joining us. Lastly, we will be hearing from Elizabeth Randolph before we go to some questions from the committee. Liz is the Legislative Director for the ACLU of Pennsylvania. Ms. Randolph, thank you for your time today, and you are in order to begin your testimony. Just pull the mic here, but just a little bit closer. Thank you.
All right. Can you all hear me okay? All right, great. So good morning, Chairman Briggs. Sorry to miss Chairman Kaufman, but also good to see members of the committee, and I'm happy to be joined by co-presenters who I look forward to meeting a little bit after today's testimony. Thank you for inviting the ACLU to participate in this testimony on pre-conviction DNA collection. I wanted to start by outlining the ACLU's constitutional concerns with pre-conviction DNA collection. Despite the U.S. Supreme Court's 2013 ruling in Maryland v. King, which held that police may collect DNA from people who have been arrested for but not yet convicted of a crime, the ACLU has argued and will continue to argue that wholesale collections of DNA are intrusive, unreasonable searches made without the individualized suspicion required by the Fourth Amendment. Indeed, Justice Scalia, interjecting mere seconds into oral argument in Maryland v. King. If you haven't heard the oral argument, it's definitely a doozy. It's good, typical Scalia fiery comments. He exposed the absurdity of using a distant promise of closing cold cases to justify gutting a foundational constitutional protection. In responding to the boasts of the Maryland solicitor that arrestee DNA matches led to several convictions, he quipped, "Well, that's really good. I'll bet if you conducted a lot of unreasonable searches and seizures, you'd get more convictions too," concerns he expanded upon in his scathing dissent. Pre-conviction DNA collection undermines the presumption of innocence. It is a cardinal principle of our criminal legal system that every person accused of a crime is presumed to be innocent unless and until proven guilty beyond a reasonable doubt. Putting arrestees in criminal DNA databases turns the presumption of innocence on its head. It turns people who have not yet been convicted of any crime into permanent suspects, treating anyone arrested as presumptively guilty of something and therefore subject to compulsory genetic surveillance. The only justification for pre-conviction DNA collection is investigatory. And if law enforcement has a reason to suspect an individual, then it can and should seek a warrant. Pre-conviction DNA collection would establish a system of suspicionless and warrantless searches of people's genetic data. The Fourth Amendment requires a warrant supported by probable cause in order for a search to be legitimate. proponents of expanding DNA collection argue that society's interest in solving crimes is paramount and therefore justifies a maximalist approach to DNA collection. But the Fourth Amendment has always demanded a balancing of this interest against civil liberties. DNA collection at arrest allows the government to do 4 things. 1, to take DNA from people upon arrest. 2, often for crimes where no DNA is present to compare it to. 3, in order to query whether it matches DNA connected to a separate crime in the database, for which 4, law enforcement has no probable cause to suspect the arrestee of committing. In other words, pre-conviction DNA collection is baseless. It neither requires suspicion nor a warrant to run a sample repeatedly through a database in the hopes of discovering a hit or a match to another crime. Allowing pre-conviction DNA collection in Pennsylvania would permit the government to use a single arrest as blanket probable cause to investigate the arrestee for a multitude of other crimes, past and future, without any showing of individualized suspicion or exigent or emergency circumstances. Furthermore, collecting, storing, and searching DNA samples is uniquely invasive for 3 reasons. First, DNA is not like a fingerprint. The amount of personal and private data contained in a DNA specimen makes its seizure extraordinary in both its nature and scope. DNA samples can provide insights into the most personal family relationships and the most intimate workings of the human body. Second, unlike fingerprints, DNA is inherently relational because genetic information pertains not only to the individual whose DNA is sampled, but to everyone who shares in that person's bloodline. Potential threats to genetic privacy extend well beyond the millions of people whose samples are currently on file. An intrusion on one person's privacy may facilitate the intrusion on another person's privacy. And third, DNA data breaches are unique in that they are irretrievable. A single breach of a biometric database is an exceptionally catastrophic breach. Not only does it spill the most sensitive information about you and your family to anyone able to access it, but it's also irretrievable, because while you can change your password, you cannot change your DNA. Finally, expanded DNA collection puts communities of color under heightened genetic surveillance. The expansion of forensic DNA collection would exacerbate the biases and structural racial inequalities embedded in our criminal legal system. People of color are disproportionately represented at every phase of the criminal legal system. They are routinely suspected, stopped, searched, arrested, and convicted at disproportionately higher rates than their white counterparts. There are already dramatic disparities in the racial composition of DNA databases, where DNA profiles from Black persons are collected at 2 to 3 times the rates of white persons. Next, I'd like to briefly address expanded DNA collection through the lens of the Pennsylvania Constitution. While Maryland v. King ruled that pre-conviction DNA collection does not constitute an unreasonable search, the Pennsylvania Supreme Court has repeatedly ruled that Article 1, Section 8 of the Pennsylvania Constitution provides a more expansive protection than the Fourth Amendment, especially as it relates to privacy rights. That said, in 2 cases, the Pennsylvania Superior Court agreed that pre-conviction DNA collection is not an unreasonable search under the state constitution. However, it is not clear whether this logic would extend to the breadth of DNA collection proposed in current and previous Pennsylvania bills. Neither Superior Court case addressed collection of DNA evidence for less serious crimes or its use in unrelated crimes for which the arrestee was not charged. In both cases, swabs were conducted for identification purposes in which probable cause existed for both defendants. As such, the ACLU of Pennsylvania believes that 1, pre-conviction DNA collection in PA is not settled law, specifically as it relates to the breadth of offenses that would qualify for collection under current and previous bill proposals. And 2, there's reason to believe that a challenge to the scope of the collection proposed under these bills would be viable on the grounds that it would violate Article 1, Section 8 of the Pennsylvania Constitution. I would like to conclude by asking that legislators take expanded DNA collection out of the realm of criminal law for a moment and instead view it primarily from a privacy and big government perspective. Consider this an exercise in putting on your libertarian hats, if you have one. Legislators often defend bills that expand criminal law by arguing that police and prosecutors need more tools in their toolbox. But pre-conviction DNA collection goes well beyond a simple tool. It would create a Pandora's box of new tools easily deployed to dismantle privacy protections in Pennsylvania. any expansion of pre-conviction DNA collection will be administered by an increasingly weaponized law enforcement and justice system. Our most personal and private genetic data would be available not just to Pennsylvania and state and local authorities, but also accessible to federal authorities and uploaded into federal databases, regardless of who is at the helm. And the rapid pace of technological and scientific advances makes it difficult to imagine all the ways in which the government could gather, analyze, track, categorize, and surveil us. Never mind the terrifying prospect of a security breach spilling our DNA all over the internet or delivering our genetic data into the hands of malign actors. Even if you believe that the benefits outweigh the risks of unleashing these new tools, you must also trust that the power you grant to an expansive government bureaucracy will be wielded competently and with constitutional restraint. If law enforcement wants a DNA sample from a suspect, they can get it, even now. All they need is a warrant. Any proposal to expand DNA collection should cause patriots to pause. DNA collection upon arrest would eliminate the only check on the government's power to seize your genetic data: a warrant requiring judicial approval based on a signed affidavit of probable cause. Without a warrant, the only barrier to accessing your most private information is the bare minimum threshold of probable cause for an arrest. And when that happens, then it's fair to say that privacy as a matter of law in Pennsylvania is functionally meaningless. Although state legislators cannot fix or prevent harm that happens on the federal level, they can embrace the protections provided under the Pennsylvania Constitution to shield residents of the Commonwealth from such a needless and dangerous invasion of privacy. In my written testimony, I listed a few examples of how DNA collection has and could run amok and quickly spiral into the creation of a veritable Eye of Sauron surveilling our genetic landscape. I won't detail them today, but briefly, examples include the explosion of immigrant DNA being seized by ICE and Border Protection, including from children as young as 4. The discovery by wildlife researchers that human mitochondrial DNA can be retrieved from water and air, known as environmental or eDNA, leading one researcher to warn that just by breathing, you're discarding DNA in a way that can be traced back to you. Local law enforcement agencies have been amassing their own DNA databases of potential suspects, also referred to as rogue databases. One is still currently, I think, continuing in Bucks County, which operate under their own rules. The use of rapid DNA machines in local police departments operated by officers without clear protocols and after, at most, just a few hours of training. Or take, for example, a California DA's office engaged in offering plea deals and dismissals for misdemeanor offenses, but only in exchange for surrendering a DNA sample. Or finally, maybe you heard the horror story about San Francisco's police crime lab entering DNA profiles from sexual assault victims into a suspect database, leading one woman to be arrested for retail theft based on her years-old rape kit DNA. Yes, pre-conviction DNA collection was narrowly upheld by the U.S. Supreme Court. But just because the state is permitted to do something doesn't mean it should. Authorizing law enforcement to accumulate genetic data from people without a warrant flies in the face of our most foundational constitutional principles. Pennsylvanians have the right to be considered innocent until proven guilty. We have the right to be free from unreasonable searches and seizures by the government. We expect to be granted due process of law. And Pennsylvanians have a reasonable expectation of privacy. And when it comes to that privacy, there isn't anything more personal than our genetic information. DNA collection of people not convicted of a crime undermines these fundamental principles. And I'll just end on a personal note. I've been at the ACLU now for almost 9 years as legislative director. And each session, there seems to be a particularly dangerous bill that causes us to really sort of pay attention, that we are really alarmed by. These proposals for expanded DNA collection is absolutely, this is sort of the banner bill that would put us into overdrive. This session would mark the 6th attempt since 2011 to expand DNA collection to arrestees in Pennsylvania. Each time the ACLU of Pennsylvania has worked feverishly to defeat it. In almost every case, the bill originated in the Senate and died in the House. We're sort of counting on you all to pay particular attention to this. But how did that happen? Typically by stitching together opposition from our conservative libertarian allies and liberals and progressives. Last session, the newest member of the resistance, Senator Chris Dush, voted with the Democrats on Senate Judiciary against the bill. This session, there were only 2 votes against Senate Bill 912 in Senate Law and Justice, and those 2 no votes were Senators Wayne Fontana and Don Kiefer. I implore the members of the committee and all members of the House to think long and hard about the seen and unforeseen consequences of unleashing this tool in Pennsylvania, because once it's in the wild, you can't put that tool back in its box. Thank you for inviting us to testify today.
Dr. Randolph, thank you for participating in today's informational meeting and helping us to inform this important issue. Now that the testifiers have concluded their remarks, we will open the floor to questions from the members. Dr. Romy, you're going for the mic. Did you want to go before questions? Representative Schusterman was first in the queue. If anyone else has questions, just give me a wave.
I want to thank the panel, especially Mr. Tillman and his story, and Ms. Spence, her story. So this is a two-part question. First of all, Dr. Roman, you went through a stat very fast about certain cases being closed or prosecutions happening, the number fingerprints versus DNA. What was that? I didn't catch it.
I was saying that from a prior study that we did, a randomized control trial in 5 cities, LA, Orange County, Phoenix, Denver, Topeka, we found that DNA identified otherwise unknown suspects 3 times more often than fingerprint evidence collected at the same crime scene. Okay,
thank you. So that's a large win for victims or wrongfully accused. Then I do want to bring it to what Dr. Randall was mentioning, and I'm going to back it up, and I'm going to say, in an ideal world where everyone is swabbed for DNA, which is a horrible world from your perspective, but let's just say that suddenly people are doing the right thing and the database grows. Do you view DNA, let's take away people using DNA in the wrong way. I mean, I look at people online all the time doing things and including themselves into lists, and they're just giving their information away. But let's say we all have our DNA swabbed. Wouldn't it be a huge win for victims and wrongfully accused to have a database? Or is there something inherent in DNA that you view the DNA outcomes just do not help identify wrongfully accused or the actual perpetrators of terrible crimes?
So I think that's a pretty large question. I would say a couple of things. Having your DNA in a database, there are constitutional protections that attach to any kind of seizure. Your DNA is not unique only to you. It can tell the researchers or people looking at that DNA tells them about your entire family members. So the individual information is not discrete unto you. It tells a much bigger story, and so that privacy invasion is rather significant and deep and repeated. And by that I mean the idea that we have the Fourth Amendment that protects us against unreasonable seizures. For a very specific reason, it is an absolute foundational bedrock of both the Pennsylvania and United States constitutions. The issue with how DNA samples work is that once that is in the database, you can, for whatever reason, you no longer need a warrant. You don't even need probable cause to continue to run that same sample for past and future searches. And so DNA collection or DNA testing is not always 100% accurate. It can be used in ways where, so there's a couple of other examples I give in my testimony about sort of mega databases. The FBI is sort of creating, sort of pulling together facial recognition data with like combining lots of different pieces of information to get to a point where we're looking like China, right? So I don't think that I think it would be problematic, or I don't know that I would concede the point to think that DNA as a, even in a perfect world, if everyone was sort of following the rules, that it would still somehow not be problematic in terms of being invasive. And I will say, I'll direct people, I had included in my written testimony a link to organizations that opposed this bill in the past, and one of them was the Pennsylvania Innocence Society. They do not see the value, and that they firmly believe that there's a very important balancing act that must be done before we start just scooping up information from, genetic collection. If I can just say one more thing. So I know we're not here to talk about a particular bill, but I asked one of our attorneys to run some numbers for us in Pennsylvania based on the proposals and the provisions in Senate Bill 912. And so what he did was, because Pennsylvania would allow not only arrestee data, but if once you're also charged. So in 2024, there were approximately 121,000 dockets, all criminal dockets. Of those, approximately 57,000 of those under the bill proposal would have contained qualifying offenses for which DNA would have been required. Of those charges, so many of us know prosecutors like to stack charges, when they charge people. So it's not just the arrest, but it's also the charging. If you get your DNA swabbed with all those charges, typically those charges are either reduced, doesn't mean they're necessarily innocent, but that they're reduced, dismissed, or withdrawn. Of the 57,000, approximately 17,000 of those charges were either dismissed or withdrawn. So now you're talking about collecting DNA from people, from tens of thousands of people who would have qualified in the current bill proposal that's now just sort of languishing in the database. They can get it expunged. The problem is none of these bill proposals allow for automatic expungement. It all has to be done at the behest of the defendant, who has to go to common pleas court to request that expungement.
Thank you.
Great. Dr. Roman, I think, wanted to add a little bit. Thank you, Dr. Randall.
So I'm very sympathetic to these points. I'm very sympathetic. I think everybody in the room is sympathetic to the civil liberties arguments. It's hard not to be, right? We all want to protect our privacy and each other's privacy. But I just want to make a couple points. One point is that some of these objections concern these family genealogical tests that are just a different test. This is not the test that your local lab or the state lab is doing typically. The second thing is, when you have your DNA collected, we say DNA biology, we hear all this, science. Essentially, all they're doing is they're counting the number of times a segment repeats, and that creates a number. And the number is what is collected and contained in the CODIS system. It's just a series of 20, 11, 3, 2, 14. That might be mine, right? So it doesn't tell you any information about who you are, who you're going to become, any of these sorts of things. And when the biology is tested, especially with rapid DNA collection, it gets consumed in the process of the testing. So you collect 2 samples, you send one to the lab for confirmation, one gets consumed in the first test, one typically gets consumed in the second test. All the information that remains is this series of numbers with an identifier that's protected. All of this is incredibly well regulated. Law enforcement and labs all around the country are forever pushing the FBI to loosen their restrictions and regulations on the way evidence is processed into the system, because it is so tightly regulated and so restricted. And at a moment where all these other surveillance technologies are coming out, all the biometric scans, the CCTV, all of these things that are almost entirely unregulated, to focus on the chance that there'll be mission creep within the DNA databases seems to be sort of missing the mark. This has been around through 6 administrations. You haven't seen that creep. The regulations, the constitutional protections and provisions remain almost entirely unscathed.
Thank you. Representative Schusterman, did you have anything else?
No, thank you very much for answering my question.
Thank you. We also, just before we go to the next question, joined by Representative Donahue, a member of the committee, and I saw Senator Ferry, the prize sponsor of the Senate bill, pop in. He's not, I don't think he's still here. So next in the queue is Representative Kincaid. You're in order.
Thank you, Mr. Chairman. I share the deep concerns about privacy on this. Dr. Roman, I appreciate your clarification. I think the fact that the FBI is so rigid in their restrictions absolutely speaks to the fact that there is so much DNA contained, or so much information contained within our DNA. It was a major scandal and major feature in the news when 23andMe declared bankruptcy and they were going to be selling off their assets, which included people's DNA profiles. People's DNA profiles on those kinds of sites have been used to identify family members that have committed crimes. I actually have a bill called the Genetic Privacy Act, which would allow people to have inherent ownership of their own DNA. Because right now, companies like 23andMe, like Ancestry.com, are able to, if they want to, sell off that information to insurance companies, to private industries that then use that information to decide whether or not they're going to provide you with insurance, to decide whether or not you qualify for different things. I mean, you look at things like the BRCA gene. That is something that insurance companies have been using to be able to deny people coverage, which it's. I have serious concerns that our technology and our understanding of all of the things that are contained within people's DNA is honestly very limited. It's still very much in its infancy, and allowing the collection of DNA at arrest that's the piece that I am never going to be able to get behind, because while I understand that it would allow us to solve cold cases, it does seem very much like a significant government overreach to collect someone's personal genetic data and hold it forever because they might possibly be able to be connected to another crime if it is not related to the underlying crime for which they're being charged. And I do think there is a real need to balance that. I think one person wrongly convicted for a crime is one too many, but we have to balance that with the inherent privacy rights that we are guaranteed under the Fourth Amendment. And I think that in addition to the cases that Dr. Randall brought up, I think another case that really is pertinent here is actually Riley v. California, which is a case about cell phone search and seizure. And in 2014, the Supreme Court determined that while a cell phone is the size of a cigarette pack, it is more akin to a locked trunk, a locked room. And because of all of the information that it could contain, and that there are, in fact, other ways that police and law enforcement and prosecutors can gain access lawfully to that information and prevent it from being destroyed. DNA inherently, as long as a human body exists, is not going to be destroyed, and there are ways to get those get that information. It is one additional step. If we can demonstrate that somebody is potentially implicated in another crime, we have the ability to get a warrant. It is one additional step to go before a judge and say, we need this information in order to address a cold case, in order to address something else. And that is, we have to take a balanced approach on this. And I'm certainly open to talking about collecting, DNA when it comes to an actual conviction. But when someone has not been convicted of a crime, I don't see how we can justify collecting something that is the fundamental building block of their being if they're not actually convicted of a crime, if they are not then subject to loss of liberty as the result of the government. So, I don't know that, I don't really think that I have a question, but I'm incredibly concerned at the idea that we would that we would take DNA on arrest. I think there are plenty of tools available to us to ensure that we are protecting people's privacy and also able to solve crimes. Thank you, Mr. Chairman.
Thank you, Representative. So we have two questions in the queue, Representative Bonner and Representative Rabb. Dr. Roman, did you want to, real quick? And we have 7 minutes. So.
Yeah, just super quickly. So in Ashley Spence's case, there was nobody to get a warrant about. There was no known suspect. She didn't see his face. There was no way to ever solve that crime. This is the only way to solve that crime, unless you disagree. And then the other point is, if you collect any physical evidence from a crime scene that is the suspects, you have their DNA evidence in your locker. And all you've done when you've processed it to get it into CODIS is to turn it into something that is no longer identifiable, that no longer says anything about coding regions of that DNA. But that evidence that remains locked up in the evidence locker in perpetuity has their DNA, and that could be searched at any time in the future. So it's not a huge transition to put in the database. It just makes it safer.
Representative Bonner and then Representative Rabb. And be precise.
Thank you, Mr. Chairman, and thank you to all the testifiers. You've come today with very compelling and sadly very tragic stories, but it's very helpful in understanding the issue that we now have before us. So I'm wondering, Dr. Roman, are you suggesting that the legislation be limited to violent felony arrests?
So I don't think we have great research on where the line is. How far should arrestees be expanded? I think one of the points that I was trying to make is somebody who's willing to go and burglarize your house, to go into your residence, not knowing whether you're there or not, is somebody who is likely to have a record of serious person crimes as well. So I think my perspective would be any felony arrest gets you essentially the same people are committing all of those different types of crimes.
And then why limit it to felonies if, because we're dealing with people at this stage who are all presumed innocent? Why not expand it to anyone who's arrested for a crime?
So you can make the case for that, and the case would go like this, and it's a justice case, right? So I think you said in your testimony that people of color are more likely to be stopped, searched, arrested, detained, held pretrial, convicted, sentenced longer, violated. And found to have violated the terms of their community supervision. That's a funnel. The further you get down that funnel towards incarceration, the more racially disparate that population gets. So if you're only taking people who are convicted of a violent felony, they go into the database, and that's the only thing that you're searching against. You are perpetuating those disparities. The further out you get to the point of arrest, to misdemeanors as well as felonies, the broader the pool of people you are sampling from, the less racially disparate it is, what's in the database, and who gets tested, the crime scene evidence tested against.
Are you aware of any countries that simply take the DNA at birth?
And take DNA what?
At birth.
I am not, but I know, I know in the UK, they've dramatically expanded the collection protocols, and they'd like to go even further.
All right, thank you. Again, I appreciate all your testimony today.
I think they made movies about that. Right. Representative Rabb.
Thank you, and thank you for all your testimonies. I don't know if I have a libertarian hat. However, I've been an avid genealogist and family historian for over 30 years. And as I've advised people in their journeys, they've asked me, what about the security protocols, giving your DNA away? Because I've used 23andMe and Ancestry.com. And I started using Ancestry.com when it was owned by the Church of Latter-day Saints before it was sold off to a private equity firm that has the capacity to sell it to anyone, including corporations in China, for instance. I know conservative colleagues of mine have concerns about ownership of content and user data for TikTok. We have colleagues who, since I've been in office in 2017, had been concerned about Pennsylvania data being given to the federal government through Real ID. Since working on these issues as a genealogist, my password has been hacked. I have literally over 10,000 blood relatives connected to me, all of which are exposed. So this question that I've been getting for years about, is it safe? The answer is clearly no. And these protections are of great consequence. And I think it's really, really important that we center this conversation on the realities at play, which is that our data are not safe. And how these are used and the systems in which they're used are deeply flawed. As a father of 2 African-American sons who have been exposed to things that I don't even want to think about and have to address, but do, the impact is disproportionate. And I really ask those folks who identify as libertarian and those folks who have deep privacy concerns to be very, very careful about the legislation you get behind. Thank you so much.
Thank you. Dr. Randall, real quick.
Just very briefly, I just want to say 2 things. Regarding the concern around the disparities in the data collection, I would suggest that the answer to that is to not expand the pool of people that you are collecting DNA from in order to reduce the disparities. The problem is that there are disparities for lots of other underlying reasons, and that we don't, the goal isn't to reduce disparities as such. And I would also say that, that we're certainly sympathetic to the, solving the crimes, working with victims, making sure that people are not wrongfully convicted. But, to make an argument that, I find it a bit concerning to argue that law enforcement, that this would make it more efficient for police and prosecutors to do their jobs. Of course it would. I mean, so if you take out warrants, probable cause is not like a hugely difficult burden to overcome or to meet. And that that probable cause for arrest is pretty far down on the list there. All you need to do is get a warrant for the individual case before you. But to expand, to allow DNA, those samples to exist indefinitely within a database so that routinely that privacy invasion is repeated multiple times over and over again every time that sample, a hit is run against it. There's no individualized suspicion, no individualized warrant. And I would suggest that while it might be, one might argue or want to make law enforcement's jobs easier or make it more efficient for them to do their work, I would suggest that they don't get to do that on the backs of invasions of our particular privacy. So thank you.
Thanks. So we're going to end it now. I do want to thank you all. The balance is clearly is the challenge, right? Balancing how to solve these crimes and protecting people's privacy. So in closing, I'd like to thank each of the testifiers for taking time to provide their remarks before the committee today. We appreciate your knowledge and vulnerability, and thank you for making this informational meeting so informative. I personally learned some things I did not know before today, like Representative Bonner wanted to swab everyone at birth. Your expertise on this matter will help us make better informed decisions. Looking ahead, and this always gets me in trouble, the committee does not have anything scheduled for the remainder of the year. So we'll see how long that goes. Happy holidays. Thanksgiving's next week. Have a great holiday. This committee stands adjourned. Thank you.